This is the implementing rules of Book 5 of the Labor Code of the Philippines. Book 5. Labor Relations. As amended by Department Order No. 40-03, February 17, 2003. Rule 1. Definition of terms. Section 1. Definition of terms. A. Affiliate. Refers to an independent union affiliated with a federation, national union, or a chartered local, which was subsequently granted independent registration, but did not disaffiliate from its federation, reported to the regional office and the Bureau in accordance with Rule 3, Sections 6 and 7 of these rules. B. Appeal. Refers to the elevation by an aggrieved party, to an agency vested with appellate authority, of any decision, resolution or order, disposing the principal issues of a case rendered by an agency vested with original jurisdiction, undertaken by filing a memorandum of appeal. C. Audit examiner, refers to an officer of the Bureau, or Labor Relations Division of the regional office, authorized to conduct an audit or examination of the books of accounts, including all funds, assets and other accountabilities of a legitimate labor organization and workers' association. D. Bargaining unit, refers to a group of employees sharing mutual interests, within a given employer unit, comprised of all, or less than all of the entire body of employees in the employer unit, or any specific occupational or geographical grouping within such employer unit. E. Board, refers to the National Conciliation and Mediation Board, established under Executive Order No. 126. F. Bureau, refers to the Bureau of Labor Relations. G. Cancellation proceedings, refer to the legal process, leading to the revocation of the legitimate status of a union or workers' association. H. Certificate election, or consent election. Refers to the process of determining through secret ballot, the sole and exclusive representative of the employees in an appropriate bargaining unit, for purposes of collective bargaining or negotiation. A certification election is ordered by the department, while a consent election is voluntarily agreed upon by the parties, with or without the intervention by the department. I. Chartered local. Refers to a labor organization in the private sector, operating at the enterprise level, that acquired legal personality through registration with the regional office, in accordance with Rule 3, Section 2E of these rules. J. Collective Bargaining Agreement, or CBA. Refers to the contract between a legitimate labor union and the employer concerning wages, hours of work, and all other terms and conditions of employment in a bargaining unit. K. Conciliator mediator, refers to an officer of the board, whose principal function is to assist in the settlement and disposition of labor management disputes through conciliation and preventive mediation, including the promotion and encouragement of voluntary approaches to labor disputes prevention and settlement. L. Consolidation, refers to the creation or formation of a new union arising from the unification of two or more unions. M. Deregistration of agreement, refers to the legal process leading to the revocation of CBA registration. N. Department, refers to the Department of Labor and Employment. O. Election officer, refers to an officer of the Bureau or Labor Relations Division in the regional office authorized to conduct certification elections, election of union officers, and other forms of elections and referenda in accordance with Rule 12, Sections 2 to 5 of these rules. P. Election proceedings, refer to the period during a certification election, consent or runoff election, and election of union officers, starting from the opening to the closing of the polls, including the counting, tabulation and consolidation of votes, but excluding the period for the final determination of the challenged votes and the canvass thereof. Q. Eligible voter refers to a voter belonging to the appropriate bargaining unit, that is the subject of the petition for certification election. R. Employee refers to any person working for an employer. It includes one whose work has ceased, in connection with any current labor dispute, or because of any unfair labor practice, and one who has been dismissed from work but the legality of the dismissal is being contested in a forum of appropriate jurisdiction. S. Employer refers to any person or entity who employs the services of others, one for whom employees work, and who pays their wages or salaries. An employer includes any person directly or indirectly acting in the interest of an employer. It shall also refer to the enterprise, where a labor organization operates or seeks to operate. T. Exclusive bargaining representative refers to a legitimate labor union, duly recognized or certified, as the sole and exclusive bargaining representative or agent of all the employees in a bargaining unit. U. Grievance refers to any question, by either the employer or the union, regarding the interpretation or implementation of any provision of the collective bargaining agreement, or interpretation or enforcement of company personnel policies. V. Improved offer balloting refers to a referendum by secret ballot, involving union members on the improved offer of the employer, on or before the 30th day of a strike. W. Independent union refers to a labor organization, operating at the enterprise level, that required legal personality through independent registration under Article 234 of the Labor Code and Rule 3, Section 2A of these rules. X. Interunion dispute refers to any conflict, between and among legitimate labor unions, involving representation questions, for purposes of collective bargaining, or to any other conflict or dispute between legitimate labor unions. Y. Interlocutory order refers to any order that does not ultimately resolve the main issues in a dispute. Z. Interpleader refers to a proceeding brought by a party against two or more parties with conflicting claims, compelling the claimants to litigate between and among themselves their respective rights to the claim, thereby relieving the party so filing from suits they may otherwise bring against it. AA. Intervention refers to a proceeding whereby a person, labor organization or entity not a party to a case but may be affected by a decision therein, formally moves to make himself or herself or itself a party thereto. B. Intra-union dispute refers to any conflict, between and among union members, including grievances arising from any violation of the rights and conditions of membership, violation of or disagreement over any provision of the union's constitution and bylaws, or disputes arising from chartering or affiliation of union. C. Labor organization refers to any union or association of employees in the private sector, which exist in whole or in part for the purpose of collective bargaining, mutual aid, interest, cooperation, protection, or other lawful purposes. D. Labor Relations Division refers to the 1. Labor Organization and CBA Registration Unit and 2. Med Arbitration Unit in the Regional Office. The Labor Organization and CBA Registration Unit is in charge of processing the applications for registration of independent unions, chartered locals, workers' associations and collective bargaining agreements, maintaining said records, and all other reports and incidents pertaining to labor organizations and workers' associations. The Med Arbitration Unit conducts hearing, and decides certification election or representation cases, inter or intra-union, and other related labor relations disputes. E. Legitimate labor organization refers to any labor organization in the private sector, registered or reported with the department, in accordance with Rules 3 and 4 of these rules. F. Legitimate Workers' Association refers to an association of workers, organized for mutual aid and protection of its members, or of any legitimate purpose other than collective bargaining, registered with the Department in accordance with Rule 3, Sections 2C and 2D of these rules. G. Lockout refers to the temporary refusal of an employer to furnish work, as a result of a labor or industrial dispute. H. Managerial employee refers to an employee who is vested with powers or prerogatives to lay down and execute management policies, or to hire, transfer, suspend, lay off, recall, discharge, assign or discipline employees. I. Med arbiter refers to an officer in the regional office or in the bureau, authorized to hear and decide representation cases, inter or intra-union disputes, and other related labor relations disputes, except cancellation of union registration cases. J. Merger refers to a process where a labor organization absorbs another, resulting in the cessation of the absorbed labor organization's existence, and the continued existence of the absorbing labor organization. K. National union, or federation, refers to a group of legitimate labor unions in a private establishment, organized for collective bargaining or for dealing with employers, concerning terms and conditions of employment for their member unions, or for participating in the formulation of social and employment policies, standards and programs, registered with the Bureau in accordance with Rule 3, Section 2B of these rules. L. Organized establishment refers to an enterprise where there exists a recognized or certified sole and exclusive bargaining agent. M. Preventive mediation cases refer to labor disputes, which are the subject of a formal or informal request for conciliation and mediation assistance, sought by either of both parties, or upon the initiative of the board. N. Rank and file employee refers to an employee whose functions are neither managerial nor supervisory in nature. O. Regional director refers to the head of the regional office. P. Regional office refers to the office of the Department of Labor and Employment at the administrative regional level. Q. Registration refers to the process of determining whether the application for registration of a union or workers' association and collective bargaining agreement complies with the documentary requirements for registration prescribed in Rules 3, 4 and 17 of these rules. R. Related labor relations dispute refers to any conflict between a labor union and the employer, or any individual, entity or group that is not a labor union or workers' association. S. Runoff election refers to an election between the labor unions receiving the two highest number of votes in a certification or consent election with three or more choices, where such a certified or consent results in none of the three or more choices, receiving the majority of the valid vote cast. Provided that the total number of votes for all contending unions is at least 50% of the number of votes cast. T. Secretary refers to the head of the department. W. Strike refers to any temporary stoppage of work by the concerted action of employees, as a result of a labor or industrial dispute. V. Strike area refers to the establishment, warehouse, depots, plants or offices, including the sites or premises used as runaway shops of the employer, as well as the immediate vicinity actually used by picketing strikers in moving to and fro before all points of entrance. W. Strike vote balloting refers to the secret balloting, undertaken by the members of the union and the bargaining unit concerned, to determine whether or not to declare a strike in meetings or referenda called for that purpose. X. Supervisory employee refers to an employee who, in the interest of the employer, effectively recommends managerial actions, and the exercise of such authority is not routinary or clerical but requires the use of independent judgment. Y. Term of office refers to the fixed period of 5 years, during which the duly elected officers of a labor organization discharge the functions of their office, unless a shorter period is stipulated in the organization's constitution and bylaws. Z. Union refers to any labor organization in the private sector, organized for collective bargaining, and for other legitimate purposes. A. Voluntary arbitrator refers to any person accredited by the board as such, or any person named or designated in the collective bargaining agreement by the parties to act as their voluntary arbitrator, or one chosen by the parties, with or without the assistance of the board, pursuant to a selection procedure agreed upon in the collective bargaining agreement. B. Voluntary recognition refers to the process by which a legitimate labor union is recognized by the employer as the exclusive bargaining representative or agent in a bargaining unit, reported with the regional office in accordance with Rule 7, Section 2 of these rules. C. Workers' association refers to an association of workers, organized for the mutual aid and protection of its members, or for any legitimate purpose other than collective bargaining. Rule 2. Coverage of the right to self-organization. Section 1. Policy. It is the policy of the state, to promote the free and responsible exercise of the right to self-organization, through the establishment of a simplified mechanism, for the speedy registration of labor unions and workers' associations, determination of representation status, and resolution of inter- or intra-union and other related labor relations disputes. Only legitimate or registered labor unions shall have the right to represent their members for collective bargaining and for other purposes. Workers' associations shall have the right to represent their members for purposes other than collective bargaining. Section 2. Who may join labor unions and workers' associations? All persons employed in commercial, industrial and agricultural enterprises, including employees of government-owned or controlled corporations without original charters established under the Corporation Code, as well as employees of religious, charitable, medical or educational institutions, whether operating for profit or not, shall have the right to self-organization and to form, join or assist labor unions, for purposes of collective bargaining. Provided, however, that supervisory employees shall not be eligible for membership in a labor union of the rank and file employees but may form, join, or assist separate labor unions of their own. Managerial employees shall not be eligible to form, join or assist any labor unions for purposes of collective bargaining. Alien employees with valid working permits issued by the department may exercise the right to self-organization and join or assist labor unions for purposes of collective bargaining, if they are nationals of a country which grants the same or similar rights to Filipino workers, as certified by the Department of Foreign Affairs, or which has ratified, either ILO Convention No. 87 and ILO Convention No. 98. For purposes of this section, any employee, whether employed for a definite period or not, shall, beginning on the first day of his or her service, be eligible for membership in any labor organization. All other workers, including ambulant, intermittent and other workers, the self-employed, rural workers and those without any definite employers, may form labor organizations, for their mutual aid and protection and other legitimate purposes except collective bargaining. Rule 3. Registration of labor organizations. Section 1. Where to file. Applications for registration of independent labor unions, chartered locals, workers' associations, shall be filed with the regional office where the applicant principally operates. It shall be processed by the Labor Relations Division at the regional office, in accordance with Sections 2A, 2C, and 2E of this rule. Applications for registration of federations, national unions or workers' associations operating in more than one region, shall be filed with the Bureau of the regional offices, but shall be processed by the Bureau in accordance with Sections 2B and 2D of this rule. Section 2. Requirements for application. A. The application for registration of an independent labor union shall be accompanied by the following documents. 1. The name of the applicant labor union, its principal address, the name of its officers and their respective addresses, approximate number of employees in the bargaining unit where it seeks to operate, with a statement that is not reported as a chartered local of any federation or national union. 2. The minutes of the organizational meeting or meetings, and the list of employees who participated in the said meeting or meetings. 3. The name of all its members comprising at least 20% of the employees in the bargaining unit. 4. The annual financial reports, if the applicant has been in existence for 1 or more years, unless it has not collected any amount from the members, in which case a statement to this effect shall be included in the application. 5. The applicant's constitution and bylaws, minutes of its adoption or ratification, and the list of the members who participated in it. The list of ratifying members shall be dispensed with, where the constitution and bylaws was ratified or adopted during the organizational meeting. In such a case, the factual circumstances of the ratification shall be recorded in the minutes of the organizational meetings. B. The application for registration of federations and national unions shall be accompanied by the following documents. 1. A statement indicating the name of the applicant labor union, its principal address, the name of its officers and their respective addresses. 2. The minutes of the organizational meetings, and the list of employees who participated in the said meetings. 3. The annual financial reports, if the applicant union has been in existence for 1 or more years, unless it has not collected any amount from the members, in which case a statement to this effect shall be included in the application. 4. The applicant union's constitution and bylaws, minutes of its adoption or ratification, and the list of the members who participated in it. The list of ratifying members shall be dispensed with, where the constitution and bylaws was ratified or adopted during the organizational meetings. In such a case, the factual circumstances of the ratification shall be recorded in the minutes of the organizational meetings. 5. The resolution of affiliation of at least 10 legitimate labor organization, whether independent union or chartered locals, each of which must be a duly certified or recognized bargaining agent in the establishment where it seeks to operate. And 6. The name and addresses of the companies where the affiliates operate, and the list of all the members in each company involved. Labor organizations operating within an identified industry may also apply for registration, as a federation or national union within the specified industry, by submitting to the Bureau the same set of documents. C. The application for registration of a workers' association shall be accompanied by the following documents. 1. The name of the applicant association, its principal address, the name of its officers and their respective addresses. 2. The minutes of the organizational meetings, and the list of members who participated therein. 3. The financial reports of the applicant association, if it has been in existence for 1 or more years, unless it has not collected any amount from the members, in which case a statement to this effect shall be included in the application. 4. The applicant's constitution and bylaws, to which must be attached the names of ratifying members, the minutes of adoption or ratification of the constitution and bylaws and the date when ratification was made, unless ratification was done in the organizational meetings, in which case such fact shall be reflected in the minutes of the organizational meetings. D. Application for registration of a workers' association operating in more than one region, shall be accompanied, in addition to the requirements in the preceding subsection, by a resolution of membership of each member association, duly approved by its board of directors. E. A duly registered federation or national union may directly create a local or chapter, by issuing a charter certificate indicating the establishment of the local or chapter. The local or chapter shall acquire legal personality, only for purposes of filing a petition for certification election from the date it was issued a charter certificate. The local or chapter shall be entitled to all other rights and privileges of a legitimate labor organization, only upon the submission of the following documents in addition to its charter certificate. A. The names of the local or chapter's officers, their addresses, and the principal office of the local chapter, and B. The chapter's constitution and bylaws, provided that where the chapter's constitution and bylaws are the same as that of the federation or the national union, this fact shall be indicated accordingly. The genuineness and due execution of the supporting requirements shall be certified under oath by the secretary or treasurer of the local or chapter, and attested to by its president. Section 3. Notice of change of name of labor organizations. Where to file. The notice for change of name of a registered labor organization shall be filed with the Bureau, or the regional office where the concerned labor organization's certificate of registration, or certificate of creation of a chartered local was issued. Section 4. Requirements for notice of change of name. The notice for change of name of a labor organization shall be accompanied by the following documents. A. Proof of approval or ratification of change of name. And B. The amended Constitution and bylaws. Section 5. Certificate of registration. Certificate of creation of chartered local for change of name. The certificate of registration, and the certificate of creation of a chartered local, issued to the labor organization for change of name, shall bear the same registration number as the original certificate issued in its favor, and shall indicate the following. A. The new name of the labor organization. B. Its former name. C. Its office or business address. And D. The date when the labor organization acquired legitimate personality, as stated in its original certificate of registration, or certificate of creation of chartered local. Section 6. Report of affiliation with federations or national unions. Where to file. The report of affiliation of an independently registered labor union with a federation or national union, shall be filed with a regional office that issued its certificate of registration. Section 7. Requirements of affiliation. The report of affiliation of independently registered labor unions with a federation or national union, shall be accompanied by the following documents. A. Resolution of the labor union's board of directors approving the affiliation. B. Minutes of the general membership meeting approving the affiliation. C. The total number of members comprising the labor union, and the names of members who approved the affiliation. D. The certificate of affiliation issued by the federation in favor of the independently registered labor union. And E. Written notice to the employer concerned, if the affiliating union is the incumbent bargaining agent. Section 8. Notice of merger or consolidation of labor organizations. Where to file. Notice of merger or consolidation of independent labor unions, chartered locals and workers' associations, shall be filed with, and recorded by the regional office that issued the certificate of registration, or certificate of creation of chartered local of either the merging or consolidating labor organization. Notice of merger of consolidation of federations or national unions, shall be filed with and recorded by the Bureau. Section 9. Requirements of notice of merger. The notice of merger of labor organizations, shall be accompanied by the following documents. A. The minutes of merger convention, or general membership meetings of all the merging labor organizations, with the list of their respective members whereas prove the same. And b. The amended Constitution and bylaws, and minutes of its ratification, unless ratification transpired in the merger, convention, which fact shall be indicated accordingly. Section 10. Certificate of Registration. The certificate of registration issued to merged labor organizations, shall bear the registration number of one of the merged labor organizations, as agreed upon by the parties to the merger. The certificate of registration, shall indicate the following. A. The new name of the merged labor organization. B. The fact it is a merger of two or more labor organizations. C. The name of the labor organizations that were merged. D. Its office or business address. And E. The date when each of the merging labor organizations acquired legitimate personality, as stated in their respective original certificate of registration. Section 11. Requirements of Notice of Consolidation. The Notice of Consolidation of Labor Organizations, shall be accompanied by the following documents. A. The minutes of consolidation convention of all the consolidating labor organizations, with the list of their respective members who approve the same. And b. The amended Constitution and bylaws, minutes of its ratification transpired in the consolidation, convention or in the same general membership meetings, which fact shall be indicated accordingly. Section 12. Certificate of Registration. The certificate of registration issued to a consolidated labor organization, shall bear the registration number of one of the consolidating labor organizations, as agreed upon by the parties to the consolidation. The certificate of registration, shall indicate the following. A. The new name of the consolidated labor organization. B. The fact that it is a consolidation of two or more labor organization. C. The name of the labor organizations that were consolidated. D. Its office or business address. And E. The date when each of the consolidating labor organizations acquired legitimate personality, as stated in their respective original certificates of registration. Rule 4. Provisions common to the registration of labor organizations and workers' associations. Section 1. Attestation Requirements. The application for registration of labor unions and workers' associations, notice for change of name, merger, consolidation and affiliation, including all the accompanying documents, shall be certified under oath by its secretary or treasurer, as the case may be, and attested to by its president. Section 2. Payment of registration fee. A labor union and workers' association, shall be issued a certificate of registration upon payment of the prescribed registration fee. Section 3. Accompanying documents. One original copy and two duplicate copies of all documents accompanying the application or notice, shall be submitted to the regional office or the bureau. Section 4. Action on the application or notice. The regional office or the bureau, as the case may be, shall act on all applications for registration, or notice of change of name, affiliation, merger and consolidation within 1 day from receipt thereof, either by A. Approving the application and issuing the certificate of registration or acknowledging the notice or report. Or B. Denying the application or notice, for failure of the applicant to comply with the requirements for registration or notice. Section 5. Denial of application, or return of notice. Where the documents supporting the application for registration or notice of change of name, affiliation, merger and consolidation are incomplete, or do not contain the required certification and attestation, the regional office or the bureau shall, within 1 day from receipt of the application or notice, notify the applicant or labor organization concerned in writing of the necessary requirements, and to complete the same within 30 days from receipt of notice. Where the applicant or labor organization concerned fails to complete the requirements within the time prescribed, the application for registration shall be denied, or the notice of change of name, affiliation, merger and consolidation returned, without prejudice to filing a new application or notice. Section 6. Form of denial of application, or return of notice. Appeal. The notice of the regional office of the Bureau, denying the application for registration or returning the notice of change of name, affiliation, merger or consolidation, shall be in writing, stating in clear terms the reasons for the denial or return. The denial may be appealed to the Bureau, if denial is made by the regional office, or to the Secretary if denial is made by the Bureau, within 10 days from receipt of such notice, on the ground of grave abuse of discretion or violation of these rules. Section 7. Procedure on appeal. The memorandum of appeal shall be filed with the regional office, or the Bureau that issued the denial or return of notice. The memorandum of appeal, together with the complete records of the application for registration, or notice of change of name, affiliation, merger or consolidation, shall be transmitted by the regional office to the Bureau, or by the Bureau to the office of the Secretary, within 24 hours from receipt of the memorandum of appeal. The Bureau or the office of the Secretary shall decide the appeal within 20 days from receipt of the records of the case. Section 8. Effect of registration. The labor union or workers' association shall be deemed registered and vested with legal personality on the date of issuance of its certificate of registration, or certificate of creation if chartered local. Such legal personality may be questioned only through an independent petition for cancellation of union registration, in accordance with Rule 14 of these rules, and not by way of collateral attack in petition for certification election proceedings under Rule 8. Section 9. Effect of change of name. The change of name of a labor organization shall not affect its legal personality. All the rights and obligations of a labor organization under its old name shall continue to be exercised by the labor organization under its new name. Section 10. Effect of merger or consolidation. Where there is a merger of labor organizations, the legal existence of the absorbed labor organization or organization ceases, while the legal existence of the absorbing labor organization subsists. All the rights, interests and obligations of the absorbed labor organizations are transferred to the absorbing organization. Where there is consolidation, the legal existence of the consolidating labor organizations shall cease, and a new labor organization is created. The newly created labor organization shall acquire all the rights, interests and obligations of the consolidating labor organizations. Rule 5. Reporting requirements of labor unions and workers' associations. Section 1. Reporting requirements. It shall be the duty of every legitimate labor union and workers' association, to submit to the regional office, or the Bureau which issued its certificate of registration, or certificate of creation of local or chapter, as the case may be, 2 copies of each of the following documents. A. Its constitution and bylaws, or amendments thereto, the minutes of adoption or ratification, and the list of members who took part therein, within 30 days from its adoption or ratification. B. Its list of elected and appointed officers, and agents entrusted with the handling of union funds, the minutes of election of officers, and the list of voters, within 30 days from the date of election or appointment. C. Its annual financial report within 30 days after the close of every fiscal year. And D. Its list of members, at least once a year or whenever required by the Bureau. The fiscal year of a labor organization shall coincide with the calendar year, unless a different period is provided in its constitution and bylaws. Rule 6. Determination of representation status. Section 1. Policy. It is the policy of the state, to promote free trade unionism, through expeditious procedures governing the choice of an exclusive bargaining agent. The determination of such exclusive bargaining agent, is a non-litigious proceeding and, as far as practicable, shall be free from technicalities of law and procedure, provided only that in every case, the exclusive bargaining agent enjoys the majority support of all the employees in the bargaining unit. Section 2. Determination of representation status. Modes. The determination of an exclusive bargaining agent, shall be through voluntary recognition, in cases where there is only one legitimate labor organization operating within the bargaining unit, or through certification, runoff or consent election as provided in these rules. Rule 7. Voluntary recognition. Section 1. When and where to file. In unorganized establishments with only one legitimate labor organization, the employer may voluntarily recognize the representation status of such a union. Within 30 days from such recognition, the employer and union shall submit a notice of voluntary recognition, with the regional office which issued the recognized labor union's certificate of registration, or certificate of creation of a chartered local. Section 2. Requirements for voluntary recognition. The notice of voluntary recognition, shall be accompanied by the original copy and 2 duplicate copies of the following documents. A. A joint statement under oath of voluntary recognition, attesting to the fact of voluntary recognition. B. Certificate of posting, of the joint statement of voluntary recognition for 15 consecutive days, in at least 2 conspicuous places in the establishment or bargaining unit where the union seeks to operate. C. The approximate number of employees in bargaining unit, accompanied by the names of those who support the voluntary recognition, comprising at least a majority of the members of the bargaining unit. And D. A statement that the labor union, is the only legitimate labor organization operating within the bargaining unit. All accompanying documents of the notice for voluntary recognition, shall be certified under oath by the employer representative, and president of the recognized labor union. Section 3. Action on the notice. Where the notice of voluntary recognition is sufficient in form, number and substance, and where there is no other registered labor union operating within the bargaining unit concerned, the regional office, through the Labor Relations Division shall, within 10 days from receipt of the notice, record the fact of voluntary recognition in its roster of legitimate labor unions, and notify the labor union concerned. Where the notice of voluntary recognition is insufficient in form, number and substance, the regional office shall, within the same period, notify the labor union of its findings, and advise it to comply with the necessary requirements. Where neither the employer nor the labor union, failed to complete the requirements for voluntary recognition under Section 2 of this rule within 30 days from receipt of the advisory, the regional office shall return the notice for voluntary recognition, together with all its accompanying documents without prejudice to its resubmission. Section 4. Effective recording of fact of voluntary recognition. From the time of recording of voluntary recognition, the recognized labor union, shall enjoy the rights, privileges and obligations of an existing bargaining agent of all the employees in the bargaining unit. Entry of voluntary recognition, shall bar the filing of a petition for certification election by any labor organization, for a period of 1 year from the date of entry of voluntary recognition. Upon expiration of this 1-year period, any legitimate labor organization, may file a petition for certification election, in the same bargaining unit represented by the voluntarily recognized union, unless a collective bargaining agreement between the employer and voluntarily recognized labor union, was executed and registered with the regional office, in accordance with Rule 17 of these rules. Rule 8. Certification election. Section 1. Who may file? Any legitimate labor organization, including a national union or federation, that has issued a charter certificate to its local or chapter, or the local or chapter itself, may file a petition for certification election. A national union or federation filing a petition in behalf of its local or chapter, shall not be required to disclose the names of the local or chapter's officers and members, but shall attach to the petition, the charter certificate it issued to its local or chapter. When requested to bargain collectively in a bargaining unit, where no registered collective bargaining agreement exists, an employer may file a petition for certification election with the regional office. In all cases, whether the petition for certification election is filed by an employer or a legitimate labor organization, the employer shall not be considered a party thereto, with a concomitant right to oppose a petition for certification election. The employer's participation in such proceedings shall be limited to 1. Being notified or informed of petitions of such nature, and 2. Submitting the list of employees during the pre-election conference, should the med arbiter act favorably on the petition. Any employee has the right to intervene for the protection of his individual right. Section 2. Where to file. A petition for certification election shall be filed with the regional office which issued the petitioning union's certificate of registration, or certificate of creation if chartered local. The petition shall be heard and resolved by the med arbiter. Where two or more petitions involving the same bargaining unit are filed in one regional office, the same shall be automatically consolidated with the med arbiter who first acquired jurisdiction. Where the petitions are filed in different regional offices, the regional office in which the petition was first filed shall exclude all others. In which case, the latter shall endorse the petition to the former for consolidation. Section 3. When to file. A petition for certification election may be filed anytime, except a. When a fact of voluntary recognition has been entered, or a valid certification, consent or runoff election has been conducted within the bargaining unit, within 1 year prior to the filing of the petition for certification election. Where an appeal has been filed from the order of the med arbiter certifying the results of the election, the running of the 1 year period shall be suspended until the decision on the appeal has become final and executory. B. When the duly certified union has commenced and sustained negotiations in good faith with the employer, in accordance with Article 256 of the Labor Code, within the 1 year period referred to in the immediately preceding paragraph. C. When a bargaining deadlock, to which an incumbent or certified bargaining agent is a party had been submitted to conciliation or arbitration, or had become the subject of a valid notice of strike or lockout. D. When a collective bargaining agreement between the employer and a duly recognized or certified bargaining agent has been registered in accordance with Article 237 of the Labor Code. Where such collective bargaining agreement is registered, the petition may be filed only within 60 days prior to its expiry. Section 4. Form and contents of petition. The petition shall be in writing, verified under oath by the President of petitioning labor organization. Where a federation or national union files a petition in behalf of its local or affiliate, the petition shall be verified under oath by the President or duly authorized representative of the federation or national union. In case the employer files the petition, the owner, president or any corporate officer, who is authorized by the board of directors, shall verify the petition. The petition shall contain the following. A. The name of petitioner, its address, and affiliation if appropriate, the date and number of its certificate of registration. If the petition is filed by a federation or national union, the national president or his or her duly authorized representative shall certify under oath as to the existence of its local or chapter in the establishment, and attaching thereto the charter certificate or a certified true copy thereof. If the petition is filed by a local or chapter, it shall attach its charter certificate or a certified true copy thereof. B. The name, address and nature of employer's business. C. The description of the bargaining unit. D. The approximate number of employees in the bargaining unit. E. The names and addresses of other legitimate labor unions in the bargaining unit. F. A statement indicating any of the following circumstances. 1. That the bargaining unit is unorganized, or that there is no registered collective bargaining agreement covering the employees in the bargaining unit. 2. If there exists a duly registered collective bargaining agreement, that the petition is filed within the 60-day freedom period of such agreement. Or 3. If another union had been previously recognized voluntarily or certified in a valid certification, consent or runoff election, that the petition is filed outside the 1-year period from date of recording of such voluntary recognition, or conduct of certification or runoff election, and no appeal is pending thereon. G. In an organized establishment, the signature of at least 25% of all employees in the appropriate bargaining unit shall be attached to the petition at the time of its filing. And H. Other relevant facts. Section 5. Raffle of the case. The regional director or his or her duly authorized representative, upon receipt of the petition, shall immediately assign it by raffle to a mediator arbiter. The raffle shall be done in the presence of the petitioner, if the latter so desires. Section 6. Notice of preliminary conference. The petition shall immediately be transmitted to the assigned mediator arbiter, who shall immediately prepare and serve a notice of preliminary conference to be held within 10 working days from the mediator arbiter's receipt of the petition. The service of the petition to the employer, and of the notice of preliminary conference to the petitioner, and the incumbent bargaining agent, if any, shall be made within 3 working days from the mediator arbiter's receipt of the petition. The service may be made by personal service, by registered mail or by courier service. A copy of the petition and of the notice of preliminary conference, shall be posted within the same 3-day period, in at least 2 conspicuous places in the establishment. In multiple location workplaces, the posting shall be made in at least 2 conspicuous places in every location. Section 7. Forced intervener. The incumbent bargaining agent shall automatically be one of the choices in the certification election as forced intervener. Section 8. Motion for intervention. When a petition for certification election was filed in an organized establishment, any legitimate labor union, other than the incumbent bargaining agent operating within the bargaining unit, may file motion for intervention with the med arbiter during the freedom period of the collective bargaining agreement. The form and contents of the motion shall be the same as that of a petition for certification election. In an unorganized establishment, the motion shall be filed at any time prior to the decision of the med arbiter. The form and contents of the motion shall likewise be the same as that of a petition for certification election. The motion for intervention shall be resolved in the same decision issued in the petition for certification election. Section 9. Preliminary conference. Hearing. The med arbiter shall conduct a preliminary conference and hearing within 10 days from receipt of the petition, to determine the following. A. The bargaining unit to be represented. B. Contending labor unions. C. Possibility of a consent election. D. Existence of any of the bars to certification election under Section 3 of this rule. And E. Such other matters as may be relevant for the final disposition of the case. Section 10. Consent election. Agreement. The contending unions may agree to the holding of an election, in which case it shall be called a consent election. The mediator arbiter shall forthwith call for the consent election, reflecting the parties' agreement and the call in the minutes of the conference. The mediator arbiter shall, immediately forward the records of the petition to the regional director or his or her authorized representative, for the determination of the election officer, who shall be chosen by raffle in the presence of representatives of the contending unions if they so desire. The first pre-election conference shall be scheduled within 10 days from the date of the consent election agreement. Subsequent conferences may be called to expedite and facilitate the holding of the consent election. To afford an individual employee voter an informed choice where a local or chapter is the petitioning union, the local or chapter shall secure its certificate of creation, at least 5 working days before the date of the consent election. Section 11. Number of hearings. Pleadings. If the contending unions fail to agree to a consent election during the preliminary conference, the med arbiter may conduct as many hearings as he or she may deem necessary, but in no case shall the conduct thereof exceed 15 days from the date of the scheduled preliminary conference or hearing, after which time petition shall be considered submitted for decision. Med arbiter shall have control of the proceedings. Postponements of continuances shall be discouraged. Within the same 15-day period within which the petition is heard, the contending labor unions may file such pleadings as they may deem necessary for the immediate resolution of the petition. Extensions of time shall not be entertained. All motions shall be resolved by the med arbiter in the same order, or decision granting or denying the petition. Section 12. Failure to appear despite notice. The failure of any party to appear in the hearing or hearings when notified, or to file its pleadings, shall be deemed a waiver of its right to be heard. The med arbiter, however, when agreed upon by the parties for meritorious reasons, may allow the cancellation of scheduled hearing or hearings. The cancellation of any scheduled hearing or hearings shall not be used as a basis for extending the 15-day period with which to terminate the same. Section 13. Order or decision on the petition. Within 10 days from the date of the last hearing, the mediator arbiter shall formally issue a ruling granting or denying the petition, except in organized establishments, where the grant of the petition can only be made after the lapse of the freedom period. The ruling for the conduct of a certification election shall state the following. A. The name of the employer or establishment. B. A description of the bargaining unit. C. A statement that none of the grounds for dismissal enumerated in the succeeding paragraph exists. D. The names of the contending labor unions which shall appear in the following order. The petitioner unions in the order of the date of filing of their respective petitions. The forced intervener. And no union. E. To afford an individual employee voter an informed choice, where a local or chapter is one of the contending unions, a directive to an unregistered local or chapter, or a federation or national union representing an unregistered local or chapter, to personally submit to the election officer its certificate of creation, at least 5 working days before the actual conduct of the certification election. Non-submission of this requirement as certified by the election officer, shall disqualify the local or chapter from participating in the certification election. And F. A directive to the employer and the contending union or unions, to submit within 10 days from receipt of the order, the certified list of employees in the bargaining unit, or where necessary, the payrolls covering the members of the bargaining unit for the last 3 months prior to the issuance of the order. Section 14. Denial of the petition. Grounds. The mediator arbiter may dismiss the petition on any of the following grounds. A. The petitioning union or national union or federation is not listed in the department's registry of legitimate labor unions, or that its registration certificate has been cancelled with finality in accordance with Rule 14 of these rules. B. Failure of a local or chapter, or national union or federation to submit a duly issued charter certificate upon filing of the petition for certification election. C. Filing the petition before or after the freedom period of a duly registered collective bargaining agreement. Provided that the 60-day period based on the original collective bargaining agreement, shall not be affected by any amendment, extension or renewal of the collective bargaining agreement. D. Filing of a petition within 1 year from the date of recording of the voluntary recognition, or within the same period from a valid certification, consent or runoff election where no appeal on the results of the certification, consent or runoff election is pending. E. Where a duly certified union has commenced and sustained negotiations with the employer in accordance with Article 256 of the Labor Code, within the 1-year period referred to in Section 14D of this rule, or where there exists a bargaining deadlock which has been submitted to conciliation or arbitration, or has become the subject of a valid notice of strike, or lockout where an incumbent or certified bargaining agent is a party. F. In an organized establishment, the failure to submit the 25% signature requirement to support the filing of the petition for certification election. G. Non-appearance of the petitioner, for 2 consecutive scheduled conferences before the mediator arbiter despite due notice, and H. Absence of employer-employee relationship between all the members of the petitioning union, and the establishment where the proposed bargaining unit is sought to be represented. Section 15. Prohibited ground for the denial or suspension of the petitions. The inclusion as union members of employees outside the bargaining unit, shall not be a ground for the cancellation of the registration of the union. Said employees are automatically deemed removed from the list of membership of said unions. Section 16. Ancillary issues. All issues pertaining to the existence of employer-employee relationship, raised before the mediator arbiter during the hearing or hearings and in the pleadings, shall be resolved in the same order or decision, granting or denying the petition for certification election. All issues pertaining to the validity of the petitioning union's certificate of registration, or its legal personality as a labor organization, validity of registration, and execution of collective bargaining agreements, shall be heard and resolved by the regional director, in an independent petition for cancellation of its registration, and not by the mediator arbiter in the petition for certification election, unless the petitioning union is not listed in the department's roster of legitimate labor organizations, or an existing collective bargaining agreement, is not registered with the department. Section 17. Release of order or decision within 10 days from the last hearing. The med arbiter shall release his or her order, or decision granting or denying the petition personally to the parties on an agreed date and time. Section 18. Appeal. The order granting the conduct of a certification election in an unorganized establishment, shall not be subject to appeal. Any issue arising therefrom, may be raised by means of protest on the conduct and results of the certification election. The order granting the conduct of a certification election in an organized establishment, and the decision dismissing or denying the petition, whether in an organized or unorganized establishment, may be appealed to the office of the Secretary within 10 days from receipt thereof. The appeal shall be verified under oath, and shall consist of a memorandum of appeal, specifically stating the grounds relied upon by the appellant, with the supporting arguments and evidence. Section 19. Where to file appeal. The memorandum of appeal shall be filed in the regional office where the petition originated, copy furnished the contending unions and the employer, as the case may be. Within 24 hours from receipt of the appeal, the regional director shall cause the transmittal thereof, together with the entire records of the case to the office of the Secretary. Section 20. Finality of order or decision. Where no appeal is filed within the 10-day period, the med arbiter shall enter the finality of the order or decision in the records of the case, and cause the transmittal of the records of the petition to the regional director. Section 21. Period to reply. A reply to the appeal may be filed by any party to the petition, within 10 days from receipt of the memorandum of appeal. The reply shall be filed directly with the office of the Secretary. Section 22. Decision of the Secretary. The Secretary shall have 15 days from receipt of the entire records of the petition, within which to decide the appeal. The filing of the memorandum of appeal from the order or decision of the med arbiter stays the holding of any certification election. The decision of the Secretary shall become final and executory after 10 days from receipt thereof by the parties. No motion for reconsideration of the decision shall be entertained. Section 23. Transmittal of records to the regional office. Within 48 hours from notice of receipt of decision by the parties and finality of the decision, the entire records of the case shall be remanded to the regional office of origin for implementation. Implementation of the decision shall not be stayed, unless restrained by the appropriate court. Section 24. Effects of consent election. Where a petition for certification election had been filed, and upon the intercession of the med arbiter, the parties agree to hold a consent election, the results thereof shall constitute a bar to the holding of a certification election for 1 year from the holding of such consent election. Where an appeal has been filed from the results of the consent election, the running of the 1-year period shall be suspended until the decision on appeal has become final and executory. Where no petition for certification election was filed, but the parties themselves agreed to hold a consent election, with the intercession of the regional office, the result thereof shall constitute a bar to another petition for certification election. Section 25. Effects of early agreements. The representation case shall not be adversely affected by a collective bargaining agreement registered before or during the last 60 days of a subsisting agreement, or during the pendency of the representation case. Section 26. Non-availability of med arbiter. Where there is no med arbiter available in the regional office, by reason of vacancy, prolonged absence, or excessive workload as determined by the regional director, he or she shall transmit the entire records of the case to the Bureau, which shall within 48 hours from receipt, assign the case to any med arbiter from any of the regional offices or from the Bureau. Rule 9. Conduct of certification election. Section 1. Raffle of the case. Within 24 hours from receipt of the notice of entry of final judgment, granting the conduct of a certification election, the regional director shall cause the raffle of the case to an election officer, who shall have control of the pre-election conference and election proceedings. Section 2. Pre-election conference. Within 24 hours from receipt of the assignment for the conduct of a certification election, the election officer shall cause the issuance of notice of pre-election conference, upon the contending unions, which shall be scheduled within 10 calendar days from receipt of the assignment. The employer shall be required to submit the certified list of employees in the bargaining unit, or where necessary, the payrolls covering the members of the bargaining unit at the time of the filing of the petition. Section 3. Waiver of right to be heard. Failure of any party to appear during the pre-election conference despite notice, shall be considered as a waiver of its right to be present, and to question or object to any of the agreements reached in the pre-election conference. However, this shall not deprive the non-appearing party of the right to be furnished notices of, and to attend subsequent pre-election conferences. Section 4. Minutes of pre-election conference. The election officer shall keep the minutes of matters raised and agreed upon during the pre-election conference. The parties shall acknowledge the completeness and correctness of the entries in the minutes by affixing their signatures thereon. Where any of the parties refuse to sign the minutes, the election officer shall note such fact in the minutes, including the reason for refusal to sign the same. In all cases, the parties shall be furnished a copy of the minutes. The pre-election conference shall be completed within 30 days from the date of the first hearing. Section 5. Qualification of voters. Inclusion/exclusion. All employees who are members of the appropriate bargaining unit, sought to be represented by the petitioner, at the time of the issuance of the order granting the conduct of a certification election, shall be eligible to vote. An employee who has been dismissed from work, but has contested the legality of the dismissal in a forum of appropriate jurisdiction, at the time of the issuance of the order for the conduct of a certification election, shall be considered a qualified voter, unless his or her dismissal was declared valid in a final judgment at the time of the conduct of the certificate election. In case of disagreement over the voters' list over the eligibility of voters, all contested voters shall be allowed to vote. But their votes shall be segregated and sealed in individual envelopes, in accordance with sections 10 and 11 of this rule. Section 6. Posting of notices. The election officer shall cause the posting of notice of election, at least 10 days before the actual date of the election, in two most conspicuous places in the company premises. The notice shall contain a. The date and time of the election. b. Names of all contending unions. c. The description of the bargaining unit, and the list of eligible and challenged voters. The posting of the notice of election, the information required to be included therein, and the duration of posting, cannot be waived by the contending unions of the employer. Section 7. Secrecy and sanctity of the ballot. To ensure secrecy of the ballot, the election officer, together with the authorized representatives of the contending unions and the employer, shall before the start of the actual voting, inspect the polling place, the ballot boxes and the polling booths. Section 8. Preparation of ballots. The election officer shall prepare the ballots in English and Filipino, or the local dialect. The number of ballots should correspond to the number of voters in the bargaining unit, plus a reasonable number of extra ballots for contingencies. All ballots shall be signed at the back by the election officer, and an authorized representative each of the contending unions. A party who refuses or fails to sign the ballots, waives its right to do so, and the election officer shall enter the fact of refusal, or failure, and the reason therefor in the records of the case. Section 9. Marking of votes. The voter must put a cross, or check mark, in the square opposite the name of the union of his choice, or no union if he or she does not want to be represented by any union. If a ballot is torn, defaced or left unfilled in such a manner as to create doubt or confusion, or to identify the voter, it shall be considered spoiled. If the voter inadvertently spoils a ballot, he or she shall return it to the election officer, who shall destroy it and give him or her another ballot. Section 10. Procedure in the challenge of votes. The ballot of the voter who has been properly challenged during the pre-election conferences, shall be placed in an envelope, which shall be sealed by the election officer, in the presence of the voter and the representatives of the contending unions. The election officer shall indicate on the envelope, the voter's name, the union challenging the voter, and the ground for the challenge. The sealed envelope shall then be signed by the election officer, and the representatives of the contending unions. The election officer shall note all challenges in the minutes of the election proceedings, and shall have custody of all envelopes containing the challenged votes. The envelopes shall be opened, and the question of eligibility shall be passed upon by the mediator arbiter, only if the number of segregated votes will materially alter the results of the election. Section 11. On-the-spot questions. The election officer shall rule on any question relating to and raised during the conduct of the election. In no case, however, shall the election officer rule on any of the grounds for challenge specified in the immediately preceding section. Section 12. Protest. When perfected, any party in interest may file a protest based on the conduct or mechanics of the election. Such protests shall be recorded in the minutes of the election proceedings. Protests not so raised are deemed waived. The protesting party must formalize its protest with the med arbiter, with specific grounds, arguments and evidence, within 5 days after the close of the election proceedings. If not recorded in the minutes and formalized within the prescribed period, the protest shall be deemed dropped. Section 13. Canvassing of votes. The votes shall be counted and tabulated by the election officer, in the presence of the representatives of the contending unions. Upon completion of the canvass, the election officer shall give each representative a copy of the minutes of the election proceedings and results of the election. The ballots and the tally sheets shall be sealed in an envelope, and signed by the election officer and the representatives of the contending unions, and transmitted to the med arbiter, together with the minutes and results of the election, within 24 hours from the completion of the canvass. Where the election is conducted in more than one region, consolidation of results shall be made within 15 days from the conduct thereof. Section 14. Conduct of election and canvass of votes. The election precincts shall open and close on the date and time agreed upon during the pre-election conference. The opening and canvass of votes shall proceed immediately after the precincts have closed. Failure of the representative or representatives of the contending unions to appear during the election proceedings and canvass of votes shall be considered a waiver of the right to be present, and to question the conduct thereof. Section 15. Certification of collective bargaining agent. The union which obtained a majority of the valid votes cast, shall be certified as the sole and exclusive bargaining agent of all the employees in the appropriate bargaining unit, within 5 days from the day of the election, provided no protest is recorded in the minutes of the election. Section 16. Failure of election. Where the number of votes cast in a certification or consent election is less than the majority of the number of eligible voters, and there are no material challenged votes, the election officer shall declare a failure of election in the minutes of the election proceedings. Section 17. Effect of failure of election. A failure of election shall not bar the filing of a motion for the immediate holding of another certification or consent election, within 6 months from date of declaration of failure of election. Section 18. Action on the motion. Within 24 hours from receipt of the motion, the election officer shall immediately schedule the conduct of another certification or consent election, within 15 days from receipt of the motion, and cause the posting of the notice of certification election, at least 10 days prior to the scheduled date of election in 2 most conspicuous places in the establishment. The same guidelines and list of voters shall be used in the election. Section 19. Proclamation and certification of the result of the election. Within 24 hours from final canvass of votes, there being a valid election, the election officer shall transmit the records of the case to the med arbiter, who shall, within the same period from receipt of the minutes and results of election, issue an order proclaiming the results of the election, and certifying the union which obtained a majority of the valid votes cast, as the sole and exclusive bargaining agent in the subject bargaining unit, under any of the following conditions. A. No protest was filed or, even if one was filed, the same was not perfected within the 5-day period for perfection of the protest. B. No challenge or eligibility issue was raised, or even if one was raised, the resolution of the same will not materially change the results of the elections. The winning union shall have the rights, privileges and obligations of a duly certified collective bargaining agent from the time the certification is issued. Where majority of the valid votes cast results in no union obtaining the majority, the med arbiter shall declare such fact in the order. Section 20. Appeal. Finality of decision. The decision of the med arbiter may be appealed to the Secretary, within 10 days from receipt by the parties of a copy thereof. The appeal shall be under oath, and shall consist of a memorandum of appeal, specifically stating the grounds relied upon by the appellant, with the supporting arguments and evidence. Where no appeal is filed within the 10-day period, the order or decision shall become final and executory, and the med arbiter shall enter this fact into the records of the case. Section 21. Where to file appeal. The memorandum of appeal shall be filed in the regional office where the petition originated, copy furnished the contending unions and the employer, as the case may be. Within 24 hours from receipt of the appeal, the regional director shall cause the transmittal thereof, together with the entire records of the case to the office of the secretary. Section 22. Period to reply. A reply to the appeal may be filed by any party to the petition, within 10 days from receipt of the memorandum of appeal. The reply shall be filed directly with the office of the secretary. Section 23. Decision of the secretary. The secretary shall have 15 days from receipt of the entire records of the petition, within which to decide the appeal. The decision of the secretary shall become final and executory, after 10 days from receipt thereof by the parties. No motion for reconsideration of the decision shall be entertained. Section 24. Transmittal of records to the regional office. Within 48 hours from notice of receipt of decision by the parties and finality of the decision, the entire records of the case shall be remanded to the regional office of origin, for the implementation of the decision of the secretary, and shall not be stayed unless restrained by the appropriate court. Rule 10. Runoff elections. Section 1. When proper. When an election which provides for 3 or more choices, results in none of the contending unions receiving a majority of the valid votes cast, and there are no objections or challenges which if sustained can materially alter the results, the election officer shall motu proprio conduct a runoff election, within 10 days from the close of the election proceedings, between the labor unions receiving the 2 highest number of votes. Provided that the total number of votes for all contending unions is at least 50% of the number of votes cast. No union shall not be a choice in the runoff election. Notice of runoff elections shall be posted by the election officer at least 5 days before the actual date of runoff election. Section 2. Qualification of voters. The same voters list used in the certification election shall be used in the runoff election. The ballots in the runoff election shall provide as choices the unions receiving the highest and second highest number of the vote cast. The labor union receiving the greater number of valid votes cast shall be certified as the winner, subject to Section 20, Rule 9.